The second case on this morning's docket, case number 117743, State of Kansas v. Seth Collins.
May it please the Court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Seth Collins. May I please have 3 minutes for rebuttal?
3 minutes is granted.
By way of factual background, this is a case where Mr. Collins was returning. He was a divorced man who was returning with his 2 daughters to his apartment after taking them for ice cream down in Wichita. As he pulled into the apartment complex, which was horseshoe-shaped, the residence parking was along the perimeter of the horseshoe. He goes to park there, and there were 4 younger women parked in that area. The only remaining parking spot, they had their door open, blocking. He asked them to move. One of the young women, one of the twins, whose mother happened to live a floor above Mr. Collins, used a racial epithet towards him. Argument followed, saying, "Don't call me that." Ultimately, Mr. Collins goes and parks in the visitor parking on the far side of the lot. He starts walking to his apartment, sends his daughters around, their younger daughters around the other way. As the women approach him and confront him and proceed to, I believe the state said, kick his butt. I urge the court to take a look. I'm not sure if the appendices in the case show color, because I was later informed that in the transfer process they get sometimes turned to black and white. If they're not in color, the court I urge you to take a look at the exhibits in this case to see the extent of what was inflicted by these young women on Mr. Collins. He was beaten severely. In any event, it took the mother, heard the commotion, came down, got a couple licks in on Mr. Collins before telling the girls to stop. A third party pulled Mr. Collins away. He went up to his apartment to clean up. After a few minutes cleaning up, he realized his glasses had been knocked off when he was beaten. And this guy's only an assistant produce manager at Dillon's. It's a valuable thing to him. He goes outside again. Probably should have just left the glasses. But in any event, as he goes out, Miss Deere, their mother, is at the door. He says, "I just want to get my glasses." He goes, uses his cell phone, finds his glasses. As he's walking back in, probably mutters something to Miss Deere. The 2 daughters come running towards their mother. Mr. Collins goes up the stairs to a second-floor apartment. All 3, the mother and the 2 daughters, chase him up the stairs. At this point, however, he stops at the top of the stairs when they're about a step behind him and pulls out a pocket knife. Now, instead of doing the reasonable thing and letting him go, one of the daughters grabs him by the collar and yanks him. And as he's turning the knife, trying to get them away, falling down the stairs, one of the twins gets struck in the neck, which ultimately leads to injuries, killing her. Interestingly, the other twin ends up at the bottom of the stairs on top of Mr. Collins, gouging his eyes and beating him further. When they notice the injuries, she gets off him. He flees to his apartment. And that's how we have this case. The standard review in this case, I think, is critical. And as pointed out and was discussed in the case before, this is an immunity hearing. Immunity is something different than probable cause. Immunity is to take things away from the jury. The court found it in Hardy. It's long-standing law. So the district court has to act as a gatekeeper. District court did this in this case. It sounds like it's a little different from the other case in that the district court made extensive findings, went through every aspect of the related statutes, addressed each one of them, made specific factual findings, and had to weigh credibility because, quite frankly, the state's witnesses had some issues with credibility. We'll just say that at the least. Arguably, some of the things did not come out in Mr. Collins' favor. We would have much rather the district court not said that he landed the first blow in the first incident. This was not something that all fell in Mr. Collins' favor, but we're stuck with these factual findings. This court has to give deference to those findings. The problem that ended up here is the Court of Appeals did not give proper deference. The district court reweighed the facts, and the state has always asked the district court and the Court of Appeals, and now this court, to reweigh the facts. That is not proper. The correct standard is substantial competent evidence. There was substantial competent evidence here. Arguably, frankly, I think this should be a negative finding situation where you have to find that the facts were arbitrarily chosen. But even under the substantial competent evidence standard, there was substantial competent evidence for every one of the district court's findings below.
Wouldn't the negative finding approach, though, in effect nullify the legislature's statutory concept of probable cause? I understand where the thought comes from, but we still have to deal with the statute that says this is a probable cause determination.
You're talking about, I just want to clarify,
negative
you're talking about the immunity statute, not the preliminary hearing statute.
Absolutely.
Okay, I wanted to be sure which probable cause we're talking about here.
They seem to be different.
Yeah. There certainly is a difference. Because as we know, in a regular probable cause hearing, we don't have there is no factual finding by the district court. Everything is given deference to the state. I'm okay with saying probable cause. I think I feel it's gotten a little bit twisted here in how you get to, it's always awkward when it almost feels like we have double negatives going. But you have to, the standard is, the district court has to find that there was a state established probable cause that the use of force was not justified, which is difficult to get around altogether.
So what's the scenario? How does that occur?
How do they show that?
I've looked at both. We're talking essentially two different cases here. I appreciate that, but in both cases, in my mind, that has occurred. But why? In your case, how does the state do that? And I'm not asking you to be the state, but how does that occur? Once you have a claim of self-defense, you put it on, you articulate your position. How do you show probable cause that it was not justified, other than by putting a different version of what occurred on?
You have credible witnesses. I think what's interesting.
So it just gets down to the credibility of the witnesses, and that's for the court to determine, and then it's over. It's over as far as the appeal goes.
Yeah, as far as the appeal goes, yes. But if the state wants to meet its burden, that's what they have to do. I think it's interesting here. The Court of Appeals, one of the problems they made was with this false dichotomy they set up, saying the district court found he was justified in his use of force, but they were supposed to find that the state failed to show he wasn't justified. But actually, the reality is the Court of Appeals apparently didn't read the immunity order correctly, because the very last paragraph of the immunity order says the evidence failed to establish that there was probable cause that use of force was not just. So that was a false dichotomy there. It's wrong. But if you think about it, the Court of Appeals brings up a possible scenario. There could be the scenario where some people believe that the use of force was not justified, but a reasonable person could entertain the fact that it wasn't justified. That's a whole other scenario. But the problem is the state has to meet that burden. And that's a tough burden on appellate review because we're stuck with facts.
What reweighing of the evidence do you contend the Court of Appeals did?
How did the Court of Appeals reweigh the evidence? The Court of Appeals reweighed the evidence in at least 5 ways, and I brought them all up in the petition for review.
And I guess I'm looking at the Court of Appeals statement that the state met its burden, and then it has this parenthetical set off by dashes. It says the state met its burden given the district court's assessment of the conflicting evidence. That makes it look at least like the Court of Appeals is saying, we're just taking the district court's fact findings at face value. We're not reweighing. But based on those fact findings, as a matter of law, the state met its burden.
I believe that's lip service, is what
Okay.
that's called.
So, yeah.
It's saying we gave the deference, but it didn't. It said, we don't believe that these stairs could have. We don't see how someone could have possibly felt like he could have defended himself that way. I mean, the biggest and hugest red flag in this is when the Court of Appeals starts out talking about the height and weight of the parties. That's irrelevant, really. The fact that, unless it's just choosing to belittle Mr. Collins, but the fact that someone smaller beats up someone larger, that's not unheard of.
But is that
and that actually happened in this case.
Whether that's proper or not, is it reweighing the evidence?
Sure, it's an indicia that they're leading up to it, and
I mean, but that fact's not disputed, is it?
no, the fact that the heights and weights are not, but it's indicative of the fact that they
Neither is the staircase and what, I mean,
The
I
factual
understand
injury
you don't
things.
like the way the Court of Appeals interpreted, the facts. I'm just,
You're really arguing with emphasis, aren't you?
No.
In part, you're saying that it's a reweighing when they pick out additional facts from the record to support an alternate conclusion.
yeah,
You're saying that's a reweighing. I guess I think my colleague is trying to get to not the facts that they picked out that were not mentioned by the district court, but what are the facts that the Court of Appeals recited that are different from what the district court recited?
Okay, let's address
right?
the stairs. I think the stairs provide a great example. The question of whether someone was feared great bodily harm would be normally, in a non-immunity case, determined by a jury. No, we're not going to argue about that, are we? So if a jury's making that finding, it's necessarily a factual finding because juries find facts. Correct? I mean, that's true. So the district court said falling down those stairs could cause great bodily harm. That was a factual finding. He was acting as a fact finder. The Court of Appeals reweighed that fact and said, no, it's not. So that is a reweighing of fact. It's clear. That's the clearest right there. In that same finding, when we talk to the terms of swinging the knife, preventing an assault, that is counter to the fact. It ignores the fact that yes, it could potentially stop him falling down the stairs. There was testimony that he tried to grab the side of the wall as he was turning. That certainly could have stopped that. The fact that it could have stopped another assault, which the district court mentioned twice in two of its paragraphs, at least twice in two of its paragraphs in its order. That's a factual finding right there. And it reweighed the aggressor findings. Again, even though it said it wasn't really going to reach the aggressor things, it actually did. So there's a lot of double speak in the Court of Appeals opinion there. I want to get back to really the main premises here, as in terms of all these factual findings that the district court made. It made all these findings, and then it had to decide if it was justified to use deadly force. The main aspects of that were its findings. He didn't cause any physical contact. He posed no threat to any of them. That was in paragraph 27, and paragraph 19, and paragraph 9I. So that in and of itself, right there, he's not an aggressor. Then he had just been beaten. That was a factual finding. Suffered significant injuries to the face, head, and other portions of his body from the first incident. Paragraph 9F, factual finding. 9 stairs on the carpet, 9M. A fall from them could cause great bodily harm. Paragraph 24, all factual findings. So really, when you look at those findings, it said, yeah, deadly force is justified. It's really a question, this is different, we say probable cause, but it almost is a step away, because if you make the appropriate if certain factual findings are made, you're stuck, really. It's a really simple probable cause determination. I believe these people, and if you believe these things, there's no real alternative but to find that if he was justified, then that meets the probable cause standard that
It's an
the district court
overfinding
failed
almost.
to show. Yes,
I
exactly.
mean, the district court didn't even have to go that far.
Exactly. It found both that he was justified, which he didn't need to find, and that the state failed to meet its burden of proving it wasn't justified. So it's really more than actually was necessary.
Counsel, I think we understand your point, and you're out of time. I'd like to save the rest of your remarks for rebuttal.
Thank you. I think that's what I'll do.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. The state has multiple problems with the district court's ruling, and of course we agree with the Court of Appeals. We think that the district court made both incorrect and unsupported factual findings, and that it made incorrect legal rulings. But before I get to that, I want to just emphasize from a factual standpoint what happened in this case. There were 2 physical encounters that night. The defendant made both of them physical. He initiated the use of force on both occasions. In the initial parking lot encounter, and counsel conceded this, the district court made a factual finding that the defendant was the one who turned that encounter physical. He was the one who initially pushed himself up against one of the twins' friends, and he also was the one who then threw the first punch. So that's an unchallenged factual finding of the district court, that the defendant was the one who turned what to that point had simply been a verbal disagreement in which, admittedly, everybody involved on both sides was acting foolishly. No doubt about it. But the girls and their mom and their friends had not done anything illegal. They had not used any force, and they had not threatened him in any way. It was just insults. But there was no threat to kill. There was no threat to do violence. It was just an argument until the defendant turns it physical. Now, counsel has made much of the fact that the defendant got the worst end of that fight, and that the prosecutor acknowledged or used the phrase, got his butt kicked. To that, my response is, and I don't mean this to sound flip, so what? He chose to start a fight where he was outnumbered. He turned it physical. He does not now get to use that to say, oh, I had earlier gotten my butt kicked by these people, and so that makes my later actions reasonable.
Okay, what's the evidence that he was the aggressor in the second
In the
physical encounter?
In the stairwell, he was the one. Again, nothing physical had happened. There was testimony from both sides, and it was disputed about what exactly was said, but I think it's fair to say that there was testimony from numerous witnesses that there had been more words exchanged as he was entering the back of the building and heading up the stairs. But again, even by the defendant's own account, nothing physical had happened. The women had not grabbed him. They hadn't pushed him. I think that he said at the most was that there might have been some incidental brushing against one another as they were all in this narrow stairwell. But there was nothing physical. He initiated force by displaying and brandishing the knife. And I think the statutes talk about the fact that the use, when it defines what is considered use of force, it's not only physically contacting another person, but it can be displaying the means of force. And so again, we have another nonviolent encounter where there are people that are simply walking up the stairs in a complex that I can't emphasize enough. These people live there. So it's not as...
And they just coincidentally, all 3 of them happened to be a step behind him up the stairs as he went up to the landing. Is that your characterization of this? Because the district court seemed to find otherwise.
I think that's... I don't necessarily know that the state has to prove that it was coincidental, because the point being, they're not doing anything illegal. They're simply walking up the stairs in a building that they have every bit as much right to be in as the defendant. Now, as far as the trip up the stairs, and that's where I think that some of these factual findings are unsupported by the testimony and the evidence. The defendant's testimony was that because he had gotten so thoroughly beaten in this first encounter that he was incapable of moving quickly at this point. So he said that he was walking at a normal pace at best. He also testified that when he started up the stairs, these victims were within 1.5 feet. They were within 1.5 feet. He was walking at a normal pace, and in his words, they, the victims, were on a mad dash behind him. Yet despite the fact they were within 1.5 feet at the start of the stairwell and that they were on a mad dash and he was walking at a normal pace, they were still 1.5 feet behind him when he got to the top of the stairs.
Aren't you now asking us to reweigh the evidence?
Yeah.
No, because that's in the record.
Whether it's in the record is not the question. The question is, what did the district court find? And it appears to me in paragraphs 33 and 34 that the district court found as a fact the totality of the evidence does not support a finding that Collins was the aggressor. And
Well, that's a legal conclusion. I mean, the conclusion that he was not the aggressor is a legal conclusion based on facts. And again, that's where my point is. The court overlooked an undisputed fact. And this is where, again, I think that not only are some of the findings not supported, but they're internally contradictory.
Before you go much further, can you clarify for me what you think our standard of review is? Is it a negative finding?
It is, well, the standard review is you look for substantial competent evidence to support the district court's factual findings, and then the ultimate legal conclusion is de novo review. So whether you phrase it as a negative finding, and the case law itself in Hardy talks about it being a substantial competent evidence standard. And so I think that's my best answer on that. And here, as far as the factual findings, one way that the court contradicted itself is that in one portion of the ruling, it specifically found that he had brandished the knife at the top of the stairs before the victims ever grabbed his shirt collar. It said that he got to the top of the stairs, turned, brandished the knife with the blade up, holding it shoulder height. But then later in the court's ruling, on page 22, paragraph 44, the court says that it's unclear when he displayed the knife. Well, which is it? You've earlier found that he displayed the knife and brandished it immediately upon getting to the top of the stairs before being grabbed or pulled by the victims. Now the court's saying somehow that it's unclear exactly when he displayed the knife. Now,
in your mind, what do you have to do to show probable cause that the use of deadly force in self-defense was not justified? What does that mean to you? And what you had to do? You had 3 days to try to do it,
right.
and I guess there's can be a difference of opinion as to whether you did it or not. But what do you think you had to do? And
that's it's certainly a tough question. And I obviously listened to the first case being argued today, and that was a major focus of the questioning. I would agree that it is something additional to what would normally happen in just a straight preliminary hearing. There's obviously an additional step that has to be.
I'm thinking it's almost like you have to. The defendant has to put on evidence that the affirmative defense might be justified, or you're trying to show that the self-defense instruction would be warranted. And if you've done that, that's enough. Where do you think this is at? I'm trying to figure that out.
Well, and I think I'll borrow, because I think this did an excellent job of describing it, from Justice Stegall. I think that perhaps the difference would be at a prelim, it's just simply a burden of production, whereas in this, it would be a burden of persuasion. So I would agree that the state can't overcome or meet its burden simply by virtue of the fact that they call a witness and the witness testifies. Because I think that the district court clearly does have the ability to make credibility findings. So if the state were to put on a witness who testifies favorably for the state, but if the district judge determines that that witness is not credible, the mere fact that that witness has testified, I don't think would be enough to carry the state's burden of persuasion in the case of a probable cause or of an immunity hearing. So I think that there is a higher the burden of persuasion is different in that respect. But I also don't think the court asked whether it's really a mini trial in essence, and I can understand. I think from a practical standpoint, especially in a case like this where there were 3 days of testimony and it was extensively litigating, from a practical standpoint, it might play out much the same way that a trial would. But I don't think that the ultimate burden is nearly as strong. I mean, it is a probable cause burden rather than a beyond a reasonable doubt. And so I think that the state does not have to overcome, we're simply arguing, and I think the Court of Appeals opinion expressed this. We're simply looking to see whether this is something that should go to a jury. And if a reasonable person could determine that the state proved by a preponderance that the use of force was not justified, then the state has met that. And in this particular case, again, there were 2 encounters. He turned both of them violent. And I think that plays into the state's argument that, as counsel pointed out, that the Court of Appeals did not specifically rule on the initial aggressor argument.
Let me ask a couple of questions. First of all, just probable cause versus reasonable doubt. The other thing we have to be remembering, I think, when we're talking about these 2 burdens, which clearly are different, one's meant to be lesser, one's meant to be greater, is that they're proving different things. And the reasonable doubt standard is applied to the state's proof at trial, that a crime was committed and that this person committed it, whereas probable cause is applied to the defendant's defense to that accusation. And I think that is a factor that I'm not sure how it plays out. Would you agree with me, though?
Yeah, it is.
It makes a difference.
It does make a difference, and it is confusing. And I think, as counsel in the first case acknowledged, I think that additional guidance would certainly be helpful because in my experience, and I've handled several of these appeals, some like this where it's a state's appeal and others in which the immunity motion was denied. I think that in general, my sense, and this is just an opinion, but I think that the district courts in the wake of Hardy are overreaching and declaring immunity in situations in which the statute was never intended to apply.
It's hard to know, and I think we could all use some guidance from the legislature. Maybe
Exactly, and I think it's difficult because
strangely written. Here's my other question, and it just has to do with when this knife came out. I just want to understand your view on this. Is there conflicting evidence on when the knife shows up, or
No.
is there agreement, or is there just, or do we have a situation where we have evidence only from one side on that?
No, that is one key area where all the witnesses that testified agreed that the knife came out before he had been grabbed. Now there was conflicting testimony as far as when he actually first stabbed. I think the surviving twin indicated that he had already stabbed before she pulled his collar, whereas he said that he did not begin stabbing until after that happened.
Kind of happened on the tumble, right?
Right.
I mean, isn't his position that both of these wounds were inflicted on the tumble?
I think so, yes.
Yeah. Which
But-
necessarily followed the grabbing of the collar.
Yes, but everybody agrees, including the defendant, that he not only pulled it, but brandished it. I mean, it wasn't like he simply got it and held it at his side. He was pointing it at them with the blade open and up.
Okay.
And that was before, and counsel argued today, well, at that point, the women, the victims, should have simply let him go, which is essentially saying that they had a duty to retreat. It's actually quite contrary. Our position, the state's position, is that at that point, the women were the ones who were entitled to use self-defense. He had displayed the use of force. They were not doing anything unlawful. We can speculate about what their motives were they really just going up to their apartment? Were they just trying to protect their mom, which was what I think some of the testimony was? Did they have some other motives in mind? But the fact is they hadn't done anything. And I would argue that to the extent that initial parking lot encounter comes into play here. If anything, that should further negate a finding that a reasonable person in the defendant's position would fear death or great bodily harm, because he knows 15 minutes earlier, he had been in a heated verbal confrontation with these same women. In fact, the prior occasion involved more women than were in the stairwell. And yet on that occasion, despite being very angry at him and despite throwing around these racial insults and other slurs, they never did anything physical to him or threatened to do anything physical to him until he pushed and then punched.
Okay, I have another question now.
Sure.
We had this related colloquy with your opposing counsel, and that is, we were asking him, tell us what the Court of Appeals did wrong. Where did they actually reweigh? So I want to talk to you about what you've just recited to us. Ways, evidence, some of which would have been necessarily weighed by the district court in reaching its conclusion, some of which may not have been mentioned, that sort of thing. There is a difference, isn't there, as a legal matter, as a court who sits in review, between reweighing conflicting evidence and looking at the record and teasing out pieces that appear to be undisputed and using them to support a legal conclusion on appeal. Do you think there's a difference?
I think there is, yes.
Okay. And one is permissible and one is not?
Right.
You can't reweigh conflicting, but you can, as an appellate court, look at a record and say, and there are these 5 other pieces of testimony or pieces of evidence that support a contrary conclusion.
Right.
And that's permissible.
And exactly. And I would argue that where counsel asserts that the district or that the Court of Appeals panel reweighed evidence, I would argue otherwise. I think that they simply recited evidence. And some of it was not even in the analysis portion of it. Some of it was just in the panel's statement of facts, such as the recitation of the party's height and weight. Those are undisputed facts. They didn't reweigh anything. Those heights and weights were testified to. They were not disputed by anybody. The court simply noted them in the statement of facts. And I would argue the other examples that counsel gave are also instances where the court simply pointed out certain facts that they didn't say anything that was inconsistent with any findings that the district court had made. So again, our position is that there were 2 encounters. He turned them both physical. These women on neither occasion did anything that was legally inappropriate. They never used force. They never threatened him. Again, we can speculate all we want about whether they behaved appropriately, and I would concede that they didn't. I don't think anybody handled themselves well that night. Nobody was the bigger person and acted like an adult and simply walked away. But again, these women had not done anything illegal in the stairwell. They were simply walking upstairs. And I'd also point out that while I know one thing that counsel takes issue with in his petition is the fact that the Court of Appeals, he thinks, essentially reweighs evidence about what could happen during a fall in the stairwell. And I think the district court placed great emphasis on the fact that, well, he was at the top, in the stairwell, and he easily could have suffered great bodily harm on a fall in the bottom of the stairs. 2 things. From a factual standpoint, he was no longer on the stairs. He had reached the landing. And I do think that mitigates, if not eliminates, some of the concern that he'd be likely to actually be, if he had not displayed the knife and brandished it, that he was in danger of being dragged down the stairs at that point. As to counsel's concern that the Court of Appeals somehow reweighed the evidence there or disputed factual findings with respect to an injury, I don't think that the district or that the panel was suggesting that it wasn't possible that somebody would be pulled down the stairs from a factual standpoint. They're just questioning the legal conclusion that could lead to great bodily harm.
That seems more a fodder for an expert on physics or medicine or both.
Yes, and I think that's what...
either one. But that doesn't seem the province of the Court of Appeals to me at all.
Well, I think that was essentially what the Court of Appeals pointed out.
It's not a legal conclusion. If you fall down the
Well,
stairs, you might get hurt badly. I think we can all
Sure,
agree
and
on that.
I don't dispute that, but I guess I just wanted to point out that I think that because he was on flat ground by the time this happened, I think it would change our facts if it's a 9-step staircase and he's still on step 8 or step 9. That's different than now having reached the landing where he's now on the landing. The women are still behind him.
Counsel, I have a quick question that goes to this sort of puzzle about reweighing facts versus not reweighing, et cetera. But it has to do with the standard we're supposed to apply here. And there's lots of reasonable persons in this case, but I want to leave aside the reasonable person that's connected to the self-defense statute. And you made the statement that, and I think you get it from the Court of Appeals, that what the district court judge was supposed to do in this case was ask him or herself whether or not a reasonable person could find that Collins's actions were not justified. And that's exactly what the Court of Appeals says. The Court of Appeals talks about whether or not a reasonable person could find that Collins's acts were not justified. Where does that reasonable person come from? Is that embedded in our probable cause standard, or is it just sort of an overlay? Because the alternative is not whether a reasonable person could find, but whether the district judge finds. Do you see? Do you see what I'm asking?
Right. Yeah, and I will admit that the discussion on pages 14 and 15 of the Court of Appeals opinion is probably one of the longer discussions that I've seen as to what exactly probable cause means. They give several different alternatives, and they say stated another way and then stated yet another way. I think that where they looking at what the opinion states, they initially bring in.
Well, this distinction could make all the difference in these cases. Is the district judge supposed to ask him or herself, could a reasonable person find this? Or is the district court judge supposed to ask him or herself, do I find this?
I think that it's the former. I think that it is the reasonable person standard.
And you think that comes from our case law defining probable cause? Right? Is that?
Yes, I think, yes, in large part, yeah. Because again, this court has told us in cases like Altruis and Hardy that this is a probable cause standard.
But is that probable cause standard a reasonable person standard?
I would argue that it is, yes, just based on.
Have we ever said that outright?
In the context of immunity or?
In any context.
In any context.
I guess off the top of my head, I don't know one way or the other the answer to that question.
Here's how Altruis defined probable cause, if this is of any assistance. Evidence sufficient for a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the defendant's guilt despite his claim of justified use of force immunity.
Thank you, Your Honor. And I would argue that language does indicate that it's a reasonable person standard as opposed to simply the judge's personal view, because...
And if that's right, would it be your position that because the district court never cites to a reasonable person standard, that's just a mistake of law and it needs to go back?
That would certainly be a mistake of law, yes. The failure to apply or even acknowledge a reasonable person standard would be an error of law.
If that's the standard.
Right, sure.
Okay.
So when the court said Mr. Collins reasonably believed that use of deadly force was necessary to prevent great bodily harm to himself, that is the wrong test?
Well, again, I guess that could be interpreted two ways. Is the judge saying that he himself has made that determination, or is he saying... I think that's also where the difference comes in between saying... I think that's where the Court of Appeals had issue and said, well, the district court seemed to be focused on whether the defendant has actually shown self-defense was justified, as opposed to focusing on whether the state has shown that a reasonable person could conclude otherwise. And I think that's where the tension comes in, that the court, in saying that he reasonably believed that, he went beyond what he was supposed to do. The district court was not supposed to determine whether he actually was acting in self-defense. He was supposed to determine whether we had met our burden of showing that a reasonable person could determine otherwise.
In fact, a judge could, in his or her own mind at least, think, based on this evidence, if it was up to me, I don't think the state has met its burden. But I could see how a reasonable person viewing the same evidence might disagree with me.
Exactly. Just as on this court, 4 of you might think one way and think, well, if I were the sole person deciding this, that I think that this was reasonable, and 3 of you might decide otherwise.
That's a pretty clear way to distinguish between a probable cause burden versus a kind of a jury type burden.
Yes, I think that's exactly. I think that's well put, and I think that's consistent with the case law. I think it's consistent with probable cause in general. That the judge should not sit there and determine whether he or she themselves thinks that it was reasonable, but whether reasonable minds could differ. Essentially,
Counsel, given your experience this morning and your experience wrestling with these appeals since Hardy, I want to ask you the same question I asked the state in the earlier case. Does the state believe that the language of Hardy needs some refinement or change, or is this just a situation where the Hardy structure is fine? We just need more examples of its application through a development of the case law. Or maybe there's a third alternative, but those are the only 2 I can come up with.
Right.
But what's your thought on this?
I certainly think that more guidance and refinement would be helpful.
What's that mean? Do we change the language in Hardy, or do we just apply it in different circumstances? Seems to me you're getting guidance one way or the other.
Sure.
I need to know whether we have to change syllabus paragraphs or language.
I don't know that you necessarily would need to change, but maybe adding additional language. Clearly, you're right. As more of these cases come before the appellate courts, just by example, there will be additional guidance to practitioners. But in the meantime, rather than having to wait years for that to happen, it certainly would be beneficial, I think, for the parties to have additional clarifying language, whether that means...
So what do you want us to put?
Well, I think what the discussion that we just had with Justice Stiegel would be certainly an excellent addition to be in a situation like this. And I don't want to misquote him, but to paraphrase essentially, that where reasonable minds could differ, that in that situation a district court judge should determine that the state has in fact met its burden,
Probable cause burden.
Right, even if that particular judge thinks that the use of force was justified, that if reasonable minds could differ, that the state has carried its burden to at least get the case to trial. And I do think that type of language would be very helpful. But again...
And let me just jump in on that. But that would still be in the context of the district court having made certain credibility determinations, because if the state just produces somebody that's completely not credible, we shouldn't make a defendant defend themselves, given the immunity of this statute, on evidence that the district court finds not to be credible.
I would agree, yes. And that's why I think in this case, I don't know, even if this court doesn't do anything to change the law articulated in Hardy, my position would be that the state should still prevail here, because I do think that there were unsupported factual findings, and I think that the district court also legally erred in determining that the defendant was not the aggressor.
Let me just go back, though, and one more follow-up on this,
Sure.
This idea we're exploring. Because, and this is the tension I see, at least in these cases, if probable cause is a reasonable person standard, how does that jive with the idea that the ultimate determination here is a question of law? Because we wouldn't typically say questions of law are subject to disagreement by reasonable persons.
Well,
you see
I think,
the tension here? I mean, if the district court gets to make fact findings and then is supposed to ask itself, from these facts, could a reasonable person conclude? Doesn't that sort of defeat de novo review on the legal question?
I don't know that it would defeat de novo review. I think that
It's just this weird mixture of a question of law versus a jury question.
yeah, it's certainly a difficult.
Because juries do decide the ultimate legal question.
Exactly.
And we never
yes.
review that.
Right. But again, I know I'm well past my time, but just to sum up, I think that
Before you sum up, let me ask a question to make sure I understood what the colloquy was just a minute ago. You think that Hardy can remain as is, except the standard that the district court should use for determining as a matter of law whether the state has met its burden should be changed to correspond or be duplicated by the words we use in the probable cause determination of a reasonable person.
yes.
So the structure of Hardy in terms of findings of fact reviewed for substantial competent evidence, and then the ultimate conclusion reviewed de novo, you're fine with that. It's just the standard the district court was using.
Right. Yes. And whether that's considered a change in Hardy or simply an expansion or additional guidance, and yes, and I do feel, and I can't emphasize enough, I think that in this particular case, regardless of whether you choose to change Hardy or keep it exactly as is, our position is that the state should prevail in this scenario and that the Court of Appeals reach the right conclusion. Again, this is a situation where our position is that he clearly was the initial aggressor, not only in the parking lot, but in the stairwell, because he took what had up to that point been nothing but verbal confrontation, and he displayed the use of force. And at that point, the victims had every right to defend themselves by grabbing his collar. So he can't use the fact that, well, I was tumbling down the stairs to justify his conduct when he was the one that started that entire chain of events in motion. Had he not been the one that initially used force by displaying the knife, he never would have been the one that was. And that was one thing in the district court's ruling that I took that I especially took issue with, was that the court made a finding, I would say it's a factual finding, that at the time of the stabbing, that the defendant posed no physical threat to these women. Of course he did. He had pulled a knife and brandished it on them from 1.5 feet away. Of course he posed a threat to them at that point. So their response by grabbing his collar, I would argue, is actually a pretty tame response. They simply were trying to protect themselves at that point. It'd be no different than if he had, instead of a knife, if he had pulled a gun on them from close range. I don't think any of us would say that if you get a gun pulled on you when you've done nothing physical or aggressive, that you wouldn't have the right to try and reach out and take the gun. The victims had no obligation to simply stop, throw their hands up, and beg for mercy at that point when they had done nothing wrong. They were acting lawfully, albeit silly, I guess that night was the word to describe everybody's conduct, but they had not done anything illegal. So our position is that because the district court had made factual findings that were not supported by the evidence and ultimately drew the wrong legal conclusion, our position is that A, he was not entitled to immunity because he was the initial aggressor, and B, that he did not have a reasonable belief that he was in imminent danger because these women had done nothing to him, and he knew that moments earlier all they had done was talk until he turned it physical.
Thank you, counsel.
And just to wrap up, Your Honor, I'd like to just acknowledge that I think this will be my last time arguing before you, and it's been an honor to appear before you for all these years, and I wish you a happy retirement.
Thank you, counsel.
I'll save my best wishes for Friday when I see you again. State has it wrong. As far as they keep talking, and they've repeated this, keep saying how he instigated this at the top of the steps. They absolutely had a duty to stop. All those women were engaging in unlawful conduct. Specifically, they were assaulting him. They placed him in imminent fear of bodily harm. The district court found this. It found that he considered what had just happened outside.
Can I just ask you just a quick fact question and you move on? When your client and the girls, their daughters, gathered in their apartment prior to him going back to look for his glasses, wasn't one of the daughters on the phone with the police?
I think it was.
There was a 911 call.
Yeah.
Yeah. And did the police ever come or respond?
They didn't until the second call.
There was the
Daughter
first
called
that
again.
was the first call.
I believe that's correct.
All
It
right,
was
and
his daughter, wasn't it?
Yes.
His daughter.
His daughter.
Oh, it was all his family
His
that did
daughter
all
was.
of it.
Yeah, his daughter. And so there was no response from the police from that initial call, or you don't know if they arrived. Obviously, they didn't
They
arrive.
clearly hadn't arrived. Is
Okay.
all I know. That
But
wasn't in the
he
record.
knew there was a phone call to the police. That's all I wanted to understand. Okay, go ahead.
What's your, I'll just jump in. What's your take on this, could a reasonable person find standard that's embedded in the Court of Appeals opinion, which I asked your opposing
First of
counsel
all,
about?
I'm going to say that I think everyone's forgetting that on page 191 of the record, also paragraph 6, the district court specifically cited the correct standard and said, generally to prove probable cause, evidence must be sufficient to cause a person of ordinary prudence and causation to conscientiously entertain a reasonable belief of the accused's guilt. He was using the correct standard.
But then he never cites to what a reasonable person could find. He just goes on to say what the
When
judge
he's-
finds.
He said that's probable cause, and then he said there was no probable cause. So he did. He
So
didn't, in paragraph 51 or whatever, he didn't explicitly say that again,
Yeah.
but he had just said this is what probable cause is.
Your
and if he
argument's
said
just-
there's no probable cause, then he did.
He was applying the correct standard. He
Yeah.
doesn't have to spell it out.
You know, we don't need to repeat things over and over. I mean, there was 20 some odd, 24 pages of order as it is. And we don't need to keep repeating this. He said, he cited the correct standard. He said, we waited on Hardy to decide this. They stayed this case until Hardy came down, knowing it was going to come down. He followed the correct standard. The fact that the state doesn't like the result doesn't matter. Finishing up, I just really want to touch on this last aspect of the stairs. He had an absolute right to pull that knife out. That's the mere threatening of force. That's not the use of force, pulling the knife out. Under 5221A, you can do that when there's just imminent unlawful force. It doesn't have to be deadly force. Them assaulting him is imminent unlawful force. There's not a problem with him. He wasn't the one that instigated it. They did, and they had an absolute right. They didn't have that lawful right not to retreat because they were engaged in unlawful activity. Now, this ties back to one other thing. If the court says, well, we don't have all these explicit findings, well, that's not our fault. It's not our job to ask the court for extra factual findings. It is the state's job. If they want to make arguments on appeal, and you can ask Mr. Moncla of this, he would be the first person to tell you. It is the party who is making the argument who has the burden. It is their job to ask for the factual findings. You could ask any of those people trying to raise Freeman challenges, who has to get those findings below. It is the party moving for it. And it is not, the state can't come now and say, well, they didn't make these findings. Too bad. If you wanted those findings, it's your job to ask the district court to do it. So, with all this in mind, we would ask the court to reverse the Court of Appeals and affirm the district court because it correctly found that Mr. Collins was entitled to immunity.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.